The next thing is displays of wealth and travel plans. Jurors come from a wide variety of backgrounds. Some of them have never traveled before. Some of them have not been to exotic locales before. So if they see that you have been to Las Vegas or have been abroad to Europe, they may be jealous. And that jealousy may feed into how much they should be compensating you. If they feel like, hey, you know what? This person's well enough to go to Thailand. Why am I giving them any money? So that's another concern. Another thing is displays of wealth. Social media these days has become very popular for people to show off their bling. And that's a big problem for personal injury cases. Once again, you have the jealousy factor. It shouldn't be relevant whether somebody is posting their, fancy watch or nice jewelry, because it shouldn't have anything to do with personal injury and their case. But there is jealousy. They believe this person already has money because of what they're wearing or what they're showing. They're going to be less likely to compensate that person. Another area that we're very concerned about is the comment section on social media. We all know that after the post, people are often given an opportunity to comment on the post, and you may have a jealous friend or a jealous relative who wants to sabotage your case. It's possible. And they'll write, oh, you're not even hurt. You're just doing this to make money. Even if that wasn't true, if that is in a comment board, that could be devastating to someone's case. So that's another area that we are very concerned about. People making comments that could potentially destroy somebody's personal injury case. And so basically, for all of these reasons, if they have a serious injury, if they've been involved in something where they're claiming that they're very, very, very hurt, we want them to avoid social media as much as possible, because we believe that it will be used by the defendants against plaintiffs and can really, really cause havoc with respect to the value of their case. So another thing, people say, well, can't I just do the friends only section and not make my profile public? Well, if you make your profile public, well, then clearly the whole world can find everything. If you do it as friends only, it certainly is better. But that said, crafty investigators that work for defendants can friend your friends and get access to your posts. Now, there's been a lot of litigation as to whether that is even proper, but who wants to necessarily be involved in litigation over social media? You want your litigation to be involved about your case and about your injuries and about how it's affected you. You don't want to be involved in having month-long fights in the courthouse as to what social media posts are going to come in, what social media posts are not going to come in. So at the end of the day, my advice, if you have a personal injury case, is to lay off of social media during the time that your case is pending. It's just too many things can go wrong, and too many things are out there in the world of social media that can create a false impression for a jury, and the jury could punish you for that false impression. So that's my thoughts on social media. I also have thoughts on emails and texts as well. Once again, you can't stop emailing and texting because then you'll not be able to communicate with anyone. But keep in mind, as you email or text, that there is the possibility that anything that you write in an email or a text could be seen by someone else. So that needs to be kept in mind as well. And that's all I have. Thank you.